Hello and welcome to CAT 4884 Security Methods and Practice. In this session, we will discuss the functions of laws, regulations, and professional organizations in information security and their relationship with each other. We will also address the differences between laws and ethics. We will discuss major national laws that affect the practice of information security. In addition, this session will explain the role of culture as it applies to ethics in information security. As an information security professional, it's very important to understand the organization's legal and ethical responsibilities. The organizational information security must be up to date, adhering to the latest laws and regulations. In addition, security practitioners must watch the threat issues that need attention. To be vigilant and understand the new laws will minimize liabilities, reduce risk from electronics, and reduce losses from legal actions. Before we go further in this chapter, let's understand the meaning of both laws and ethics. Laws are the rules adopted for determining accepted behavior in modern society, and as individuals, we elect to trade some aspects of personal freedom for social order. Laws are drawn from ethics, which are defined as socially acceptable behaviors. Ethics are based on fixed moral attitudes or customs of a particular group. Some ethics are recognized as universal among cultures. As we stated before, knowing the laws will minimize the company's liability, but what does the word liability mean? Liability is a legal obligation of an entity extending beyond criminal or contract law, includes legal obligation to make restitution. In the case of information security, the company should be liable for their customer personal information. Restitution is compensation or compensating customers for wrong committed by an organization or its employees. Training should be provided to ensure that employees know what constitute acceptable behavior and know the consequences of illegal or unethical actions. Ensuring that employees know what is acceptable is called due care, while due diligence is defined as making a valid effort to protect others, continually maintaining level of effort. Jurisdiction, courts right to hear a case of the wrong was committed in its territory or involved its citizenry. Long arm jurisdiction, right of any court to impose its authority over a individual or organization if it can establish jurisdiction. We need to understand the difference between policies and laws. The policies are defined as the list of expectations that describe acceptable and unacceptable employee behavior in the workplace. Policies could be considered as laws within an organization and must be written carefully to ensure they are complete, appropriate, and fairly applied to everyone. The law is a system of rules and guidelines that are enforced on all people. To enforce policy, the written policy will be distributed to all companies' employees where they will have the chance to read it and comprehend. Once being read, the employees have to comply with company's policy and follow this policy. The enforcement will be fair, equal, and uniform through all departments. There are several types of laws. We have the civil law, which represents a wide variety of laws that are recorded in volumes of legal code available for review by the average citizen. We have the criminal law, which addresses violations harmful to society and is actively enforced through prosecution by the state. We have the tort law, which allows individuals to seek recourse against others in the uh, event of personal, physical, or financial uh, injury. And we have the private law, which regulates the relationship between the individual and the organization and encompasses family law, commercial law, and labor law. The public law regulates the structure and administration of government agencies and their relationships with citizens, and with of course, the employees and the other governmental entities, providing careful checks and balances. Examples of public law include criminal, administrative, and constitutional law. There are lots of international laws related to information security, and the US has been a leader in the development and implementation of such laws. These laws assist in creating a reliable business environment and more stable economy. There are specific penalties for individuals and organizations failing to follow requirements set of information security laws. So what are the different US laws related to information security? Let's start with general computer crime laws. The Computer Fraud and Abuse Act of 1986 is the cornerstone of many computer-related federal laws and enforcement efforts. It was amended in October 1996 with the National Information Infrastructure Protection Act of 1996, which modified several actions of computer fraud and abuse and increased the penalties for selected crimes. Severity of penalties judged on the purpose of commercial advantage, private financial gain, and in furtherness of a criminal act. The USA Patriot Act of 2001 modified a wide range of existing laws to provide law enforcement agencies with a broader latitude of actions to fight terrorism-related activities. The Communication Act of 1934 was revised by the Telecommunication Deregulation and Competition Act of 1996, which attempts to modernize the archaic terminology of the older act. These much needed updated of the terminology were included as part of the Communication Decency Act, CDA. The CDA was immediately trapped in a spiky legal debate over the attempt to define indecency and ultimately rejected by the Supreme Court. Another key law that is of critical importance for the information security profession is the Computer Security Act of 1987. It was one of the first attempts to protect federal computer systems by establishing minimum acceptable security practices. The National Bureau of Standards, in cooperation with the National Security Agency, became responsible for developing these security standards and guidelines. Information privacy is an important issue and has been discussed widely recently. The ability to collect information on an individual, combine facts from separate sources or resources, and merge it with other information has resulted in databases of information that were previously impossible to set up. The aggregation of data from multiple sources permits unethical organizations to build databases of facts with frightening capabilities. And you can watch the video provided about privacy to see, it's not real, but imagine if that would happen. It will be so scary to think like that. There are US regulations to ensure individual privacy. One of the most common rules is the privacy of customer information section of Common Carrier Regulation. This rule specifies that any exclusive information shall be used explicitly for providing services and not for any marketing purposes. It also stipulates that carriers cannot disclose this information except when necessary to provide their services. The only other exception is when a customer requests the disclosure of information and then the disclosure is restricted to that customer's information only. The Federal Privacy Act of 1974 regulates the government and the protection of individual privacy and was created to ensure that government agencies protect the privacy of individuals and businesses' information and to hold those agencies responsible if any portion of this information is released without permission. The Electronic Communication Privacy Act of 1986 regulates the interception of wire, electronic, and oral communications. The Act works in conjunction with the Fourth Amendment of the United States Constitution, which provides protections from unlawful search and capture. The Financial Services Modernization Act, or Gramm-Leach-Bliley Act, that was in 1999, requires all financial institutions to disclose their privacy policies in a way of like sharing those non-public personal information with the users. It also requires due notice to customers so that they can request that their information not be shared with third parties. And that's why in most cases you receive those information from your bank, from your credit card, from your even the internet provider or the wireless phone provider. They have to provide you with this information and they have to make sure that you agree or disagree on sharing the third-party information, your information with a third-party company. So the Act ensured that the privacy policies in effect in an organization are fully disclosed when a customer initiates a business relationship, as well as distributed at least annually for the duration of the professional association. One of the most common and most important U.S. regulations is the Health Insurance Portability and Accountability Act of 1996, the HIPAA rules, also known as the Kennedy-Casipom Act or Casipom Act. This act impacts all healthcare organizations, including small doctor practices, health clinics, life insurance, and universities, as well as some organizations which have self-insured employee health programs. The Act requires organizations that retain healthcare information to use information security mechanisms to protect this information, as well as policies and procedures to maintain this security. It also requires a comprehensive assessment of the organization's information security systems, policies, and procedures. There is no specification of practical or particular security technologies for each of the security requirements, only that security must be implemented to ensure the privacy of the healthcare information. The privacy standards of HIPAA severely restrict the dissemination and distribution of private health information without document consent. The standards provide patients the right to know who has access to their information and who has accessed it, and also restrict the use of health information to the minimum required for the healthcare services requirements only. Uh, and again, if you work in a hospital as security officer, you will sign a HIPAA agreement not to release any information that you see or database that you see for patients. The access to customer personal information could lead to identity theft, which occurs when someone uses your personal information such as your name, social security number, and credit card number without your permission to commit fraud or other crimes. If you suspected identity theft, you have to report to the three dominant consumer reporting companies, Equifax, Experian, and TransUnion, that your identity might be stolen. Close compromised accounts and dispute any new accounts that have been opened without your permission. Register your concern with the Federal Trade Commission and report the incidents to either to the local police or the police in the location where the identity theft happened. On the other hand, there are export and espionage laws to protect businesses. In an attempt to protect American ingenuity, intellectual property, and competitive advantage, Congress passed the Economic Espionage Act in 1996. This law attempts to prevent trade secrets from being illegally shared. The Security and Freedom through Encryption Act of 1997 was an attempt by Congress to provide guidance on the use of encryption and provided measures of public protection from government intervention. U.S. copyright law, and we all for sure heard that, and we know it. It's as stated in a previous lecture, business intellectual property that has been targeted by hackers, and as a result, intellectual property is recognized as protected assets in the US. So basically, the US copyright law extends this right to the published word, including electronic formats. The fair use of copyrighted materials includes the use of the use to support news reporting, teaching, scholarship, and a number of other related permissions, so long as the purpose of the use is for educational or library purposes, not for profit or any other excessive use. From the financial side, there was the Sarbanes-Oxley Act of 2002, which included reforms in corporate governance and the accounting profession. The reform or the act intended to improve corporate financial reporting and internal control, strengthen audit committees, change the relationship between the auditor and client, improve auditor independence, provide additional auditor assurance over internal control, provide oversight and regulation for auditors of publicly traded companies. The Freedom of Information Act of 1966 provides any person with the right to request access to federal agency records or information not determined to be a matter of national security. U.S. government agencies are required to disclose any requested information on receipt of a written request. There are exceptions for information that is protected from disclosure, and the Act does not apply to state or local government agencies or to private businesses or individuals, although many states have their own version of the Act. In addition to the national and international restrictions placed on an organization in the use of computer technology, each state or local entities, local agency, may have a number of laws and regulations that impact operations. It's the responsibility of the information security professional to understand state laws and regulations and ensure the organization's security policies and procedures comply with those laws and regulations. Um, Companies outsource their operations and produce their product overseas. In addition, they sell their products using internet. Companies are not limited to a certain location within one country. They are globally connected to the international community. So in this case, we need to extend the laws to the international laws and make sure that we cover the company's policies and procedures also as international laws. So based on that, professionals must be sensitive to laws and ethical values of many different cultures, societies, and countries. In addition, due to the political complexities and cultural differences, there should be an international laws to protect businesses from both sides. Although these international laws are important, they are limited in their enforceability, unfortunately. Recently, the Council of Europe drafted the European Council Cyber Crime Convention, designed to create an international task force to oversee a range of security functions associated with internet activities and to standardize technology laws across international borders. It also attempts to improve the effectiveness of international investigations into breaches of technology law. This convention is well received by advocates of intellectual property rights, with its emphasis on copyright infringement prosecution. Another international collaboration is the Agreement on Trade-Related Aspects of Intellectual Property Rights that was created by the World Trade Organization. The agreement drafted the first significant international effort to protect intellectual property rights. It outlines the requirements for governmental oversight and legislation providing minimum levels of protection for intellectual property. Agreements covers 5 issues: application of basic principles of trading system and international intellectual property agreements, giving adequate protection to intellectual property rights, enforcement of those rights by countries in their own territories, settling intellectual property disputes, and transitional agreements while new system is being introduced. The Digital Millennium Copyright Act is the US version or United States version of an international effort to reduce the impact of copyright, trademarks, and privacy infringement, especially through the removal of technological copyright protection measures. The European Union also put forward Directive 95/46 EC that increases protection of individuals with regard to the processing of personal data and the free movement of such data. The United Kingdom has already implemented a version of this directive called the database right. With this, we end the session, but again, we can continue the second part of this chapter. So if you have any questions for this session, please let me know. You can either email me, or you can call me, or come to my office for any questions. Thank you and have a great day.